Think the insanity defense lets criminals get away with crimes? It's one of the rarest and least successful defenses in criminal law. The insanity defense appears in less than 1% of criminal cases and succeeds only about 25% of those times. We're talking about a defense that's attempted rarely and fails most of the time, despite popular misconceptions about crazy criminals escaping justice. There are 3 main insanity tests, each designed in ways that practically guarantee failure for defendants who genuinely need them. The Manhattan Rule, used in most jurisdictions, dates from 1843. We're applying Victorian-era psychology to modern defendants with complex psychiatric conditions. Manhattan asks whether defendants understood the nature and quality of their actions and whether they knew their actions were wrong. This sounds reasonable until you see how it works practically. A defendant with severe schizophrenia believes government agents implanted mind control devices, so they attack someone they think is activating the device. The prosecutor asks, "Did you know stabbing was wrong?" If the defendant says yes, they're legally sane. Irresistible impulse test asks whether defendants knew their acts were wrong but couldn't control their behavior due to mental illness. But courts interpret irresistible to mean literally zero self-control. If defendants paused before acting, made any rational decisions, or showed evidence of planning, their impulse was resistible and they're guilty. The standard requires defendants to be mindless robots controlled entirely by mental illness. The Durham product test, briefly used in some jurisdictions, actually made sense, which explains why it was abandoned. Durham asked whether the crime was a product of mental illness. If mental illness significantly contributed to criminal behavior, defendants could be found not guilty by reason of insanity. This test recognized how mental illness actually works. It can impair your judgment without completely destroying cognitive function. But courts feared too many defendants would qualify, so most jurisdictions abandoned Durham. The legal system forces mental health professionals to ignore psychiatric science and focus on narrow legal questions unrelated to actual mental illness. Forensic psychiatrists might conclude defendants have severe schizophrenia with active psychosis directly causing their actions, but if defendants understood that those actions were wrong, they're legally responsible.